This pretrial review is in the matter of CFI 079-2023 and is being held by way of video conference before His Excellency Justice Rene Lemiere with the sitting of the hearing taking place in Dubai. Any orders or directions made during the course or after this hearing will be issued by the registry in Dubai on the judge's instructions. The claimants are represented by White & Case. Lead counsel is Mr. Ravi Jackson. The first and third defendants are represented by Habib al-Mullah and partners. Lead counsel is Mr. Stephen Doherty. Thank you, Your Honour.
Thank you. All right. Well, Mr. Jackson, let me start with you. What matters do you want to raise?
Thank you, Your Honour. There are three short matters that we consider require Your Honour's consideration today. The first relates to the deadline for filing the trial bundle, and perhaps I can just deal with that first because that's the shortest issue. The current procedural timetable provides for reply witness statements to be filed and served on the 5th of August, although the parties have agreed in correspondence to push that back to the 8th of August. And then the trial bundle is currently due on the 11th of August. For our part, we consider that it would be sensible to push back the trial bundle by 2 weeks to allow a little further time to get it together after the witness statements have been filed. So the date that we suggest is the 25th of August 2025. And I understand from Mr. Doherty that that's agreed on his side as well.
All right. Well, that seems practical, and I agree to that.
I'm grateful, Your Honour. The second short matter relates to the arrangements for giving evidence at trial. And there are two issues in relation to that. The first issue is that there is a suggestion in my learned friend's note for the PTR that the first defendant will not be able to attend the trial in person because of a travel ban and an arrest warrant imposed upon him by the Dubai police.
All right, Mr. Jackson, should I go then? Should I ask Mr. Doherty to address that?
Yes, Your Honour. I mean, the short point I was going to make is I'm not sure you're being asked to do anything about it, but perhaps it would be best to hear from my learned friend first.
Mr. Doherty.
Yes, thank you, Your Honour. Obviously, this is a PTR. I don't really propose to labour points which have been floated in the past, but are also likely to feature at trial. Really, I think this is probably the most substantive issue for the PTR, in that it raises obvious practical difficulties. And I realise this is unlikely to have anything to do with the claimant's DIFC counsel, but the way that the claimants have chosen to litigate the broader case is one of those alarming and unfortunately all too common tactics that appear to be commonplace. But
I'm sorry to cut you off, Mr. Doherty, but can I advance to this point? Does the first defendant wish to give evidence by video link, and do you seek an order that he be permitted to give evidence by video link?
I think that there are a number of issues. One is, I think, linked to disclosure, because one of the current problems that the first defendant faces is a lack of proper knowledge about what the criminal complaint actually relates to, and that's based on the limited information that's available from the Dubai police. Now, that information is in the hands of the claimants, and we've sought information relating to what the criminal allegations are, and really this is to lay down a marker between the parties. But if there is to be an in-person trial that can proceed in the normal way, this ought to be something that can be properly resolved between the parties. At the end of the day, this is civil litigation. It's not a case in which complaints ought to be made to police, particularly where I think they've been, at least as they're understood, these are issues that have been floated before the police in the past and ultimately dropped. But if what this is a tactic to prevent the proper resolution of trial, then that is something which is a concern. In relation to how it plays out practically at trial, it probably, in my submission, goes more, goes beyond simply having the first defendant provide evidence by video link, because there's a balance issue. If one takes a view that it's important in trials like this to have evidence taking place in an in-person venue, either that ought to apply to all of the witnesses or it ought to apply to none of the witnesses. And so I don't know that it's necessarily a question of having just one witness provide evidence by video link with the rest in person, but in the interest of balance, it would probably be better if everyone was giving evidence in the same way, which would mean a wholly virtual trial rather than a trial taking place in the DIFC courtroom. That's unfortunate, and I think that Your Honour has previously expressed a view that for this case, an in-person trial would be desirable, and as it happens, we agree with that, but the reality is that the way that the claimants have chosen to litigate this has, at least for the time being, made that impossible. And if that is impossible, then I think the order we would be seeking is that the trial take place as a virtual trial.
Well, when and how is this going to be resolved, Mr. Doherty? Because the important reason, of course, is that if this is to be an in-person trial, which it is presently scheduled to be, then arrangements have got to be made for that, not least my own arrangements to be in Dubai. That's something that I suppose can be done on short notice, but it's certainly something I don't intend to do on short notice. So that needs to be resolved sooner rather than later. And secondly, perhaps you may already be able to answer this. I understand the first defendant is in Egypt, is that right?
I would have to take instructions on that. That's my understanding, but I'm not.
That's what, yeah. His witness statement. His witness
Yes.
statement gave his address in Egypt. If he is in Egypt, do you know? Have you made inquiries about whether the relevant authorities in Egypt permit a foreign court such as the DIFC to administer an oath to a person giving evidence from Egypt? I suspect that there may need to be some arrangements made or permission obtained from relevant authorities. If so, again, that's probably something that can't be done at the last minute and should be got on with. Do you know anything about that, Mr. Doherty?
I'm afraid I don't. I mean, I've conducted a number of virtual trials, and I don't recall the taking of oaths ever being a particular issue when evidence has been given
From
the
Egypt?
witnesses who are attending.
I mean, they vary, of course. For example, from the United Kingdom, it's not a problem. Most places, but I'm not sure about Egypt.
No, I'm not sure, and I'm sure that one can look into it. But I agree with Your Honour's broad sentiment that this ought to be resolved sooner than later. So one ought to put a long stop date. But at the moment,
well, let me tell you something else. Why I'm, of course, understand that these things have got practical issues, but I had hoped it would be resolved today. Not least of which because of my own convenience. On Saturday, I'm travelling from Perth to Brisbane, where I'm going to be engaged in an arbitration for about 3.5 weeks. After I return from Brisbane, about a day later, I'm going on holiday to Vietnam for about 10 days and get back in about the middle of September, which is getting to be only a week or so before the start date of the trial. So those are additional reasons why I'm anxious that this be dealt with sooner rather than later.
Well, if that is the position, Your Honour, again, faced with the reality of where we're at, and I suppose there are two factors to that. One, there's the travel ban and arrest warrant scenario, but there's also the fact that this is now no longer a sort of more than 1 week long trial. I think the current estimates are that it's somewhere between 4 to 5 days, depending which timetable you go by.
The plan you've lodged says 5 to 6 days.
I think it was with the day in reserve, and I think that Mr. Jackson had a day in reserve plus a reading day.
Well,
Yes.
the plan that I've got, which I thought had come from both of you, starts on day 1 with oral opening submissions. It concludes on day 5 with oral closing submissions, and day 6 is listed as slippage. I thought that
So
had come from both of you, but
that was the defendant's proposal, and I think that the difference, which is minor, and again, I don't know if it's an issue that needs to be ironed out today, is the Monday proposed by the claimant's timetable is set aside for a reading day, so it'd be 4 days of actual hearing time with the day in reserve. I don't think that that's the driving factor, but ultimately, the fact that Mr. Shehata is not going to be practically able to attend, at least as it stands, means that the default position in my submission, Your Honour, is that this will need to be a remote trial.
well, I'm not sure what you mean by default position, Mr. Doherty. I know, and I've had submissions from London barristers before to the effect that there is some sort of practice or presumption that if one gives evidence remotely, then all should. I can tell you that's not the position that I've adopted in the past. I don't see it as a default position. It would be something that would need to be persuaded.
Yes. Well, I think that the issue here is that there are clearly competing allegations, effectively, of dishonesty and how the relevant individuals, so that's the 2 claimants and Mr. Shehata, have acted with respect to the company, whether they've entered into transactions at conflicts and so on. There is a wide disagreement between the factual witnesses in respect of factual events. And if there is a question that the court considers will likely be best answered by hearing evidence from witnesses in person, for example, because it might assist the court in forming views when it comes to cogency or the honesty of that witness, there is an imbalance where you have the whole of the defendant's evidence in effect being given remotely, and therefore the court may well have a different take on that as compared with the claimants, who are free to attend and give evidence in person. And if the benefit of having an in-person trial is that the court can get a better feel for a witness, it's a significant factor that one of those witnesses and the only witness for the defendant's side can't attend. Because if it's going to suggest, for example, that one side's evidence is more cogent than the other purely on the basis of the form in which the evidence is given or the fact that it's given in person, and that poses problems for proceedings. And that's why we say that
that would be like this, in these days, that would be a brave submission, or in Sir Humphrey's terms, it might even be courageous.
Well, I suppose it depends on what the benefit of having an in-person trial is perceived to be.
Well, the main reason to adopt that, Mr. Doherty, you'd be aware the policy in this court is that trials for more than 3 days are held in person, trials for 3 days or less remotely, and that's without regard to witnesses and the effect of their evidence being given live or remotely. That's because of the practicalities of the logistics and the convenience of conducting a trial of more than 3 days in person rather than remotely. Now, all of that is not to say that you may be right in the one-off, all-off proposition, but that's not the reason why, as a trials, that's not the reason that informs this court's policy about in-person or remote trials.
Yes, I am aware of that. I'm also aware of at least one of the reasons or rationale. For example, if you've got a hearing which is on the boundary, say it's 3 days, and if something happens to be a matter which the witnesses are dealing with a point really which resolves in not factual dispute, but it's maybe a trial which more is about construction of a contract, then that can weigh against having an in-person trial in favour of having a remote trial. In this case, I think we agree that it's a fact-sensitive trial and that it is desirable to have evidence in person.
All right, well,
and in fact, this is first defendant wished to
all right.
attend, but it's a balance issue.
All right. Whilst Mr. Doherty, whilst I've led you down that path, it seems not a matter we're going to resolve today, but do you say, is it your position that it's within the control or the ability of the claimant to do things such that Mr. Shehata can come to Dubai without problem?
In one respect, it's difficult to say because we aren't being told exactly what the nature of the allegations are. We have asked the claimants to provide documents in relation to that, but we haven't got those yet. But it's from what has been ascertained or what has been understood, the issue relates to complaints similar to the complaints made by the second claimant before the Egyptian authorities in relation to two matters. One is in relation to payments made with respect to the assignment agreement, and the other is in relation to the movement of funds out of a HSBC account, which Your Honour will have seen from the notes is being addressed by the parties in correspondence. And in fact, is linked to the fact that Mr. Shehata was placed under travel bans in Egypt and couldn't open up a new bank account in Dubai to put the funds back into. That's what is understood to be the issues. And if that is the issue, and if these are based on complaints made by the second claimant to Dubai police, then one would assume that those complaints can be withdrawn, undertakings can be given that they're not going to be, in effect, reinstated in order to try and put pressure on Mr. Shehata when he's trying to fly over to take part in these proceedings. And so to that extent, yes, one imagines that where this is a complaint that has been made by the claimants, that it can equally be withdrawn by the claimants. Right. But we don't have information because the claimants haven't told us.
I might just ask Mr. Jackson briefly about this. Mr. Jackson, can I ask you these things? First of all, does the claimant or claimants, do they wish the trial to proceed in person or remotely?
In person, Your Honour. Our position in short is that's what the current directions provide.
Yep.
That's the policy of the court, as Your Honour noted.
No, I wasn't arguing to justify it, Mr. Jackson. I was just asking you what you wanted. You wanted in person. Secondly, is it correct, or are you able to tell me that the bans and warrants on Mr. Shehata have come about as a result of actions taken by the claimants?
So I don't have specific instructions on that, Your Honour. It's correct that criminal complaints have been made previously by the claimants against the first defendant. As to recent criminal complaints, I don't have instructions on that. But
I'm a little surprised by that, Mr. Jackson. I mean, one of the purposes of this pre-trial review is to sort out things. This is an obvious issue. It's been the subject of, it seems, discussion between the solicitors, between the lawyers, and I'm frustrated that the claimants come to this review and tell me they can't tell me.
Well, Your Honour, if I could just address that. The position that's put forward in my learned friend's note is that there has been a travel ban and an arrest warrant issued against the first defendant. And the only evidence that has been adduced in relation to that is what the first defendant says in his witness statement. And that's quoted at paragraph 6 of my learned friend's note.
But Mr. Jackson, I'm sorry to cut across you. I'm mindful of the time. I'm not asking you about the evidence. I'm asking you about what your clients know.
Yes, they're not aware of, as I understand it, of an arrest warrant or a travel ban having been issued. And the point I was making, Ron, is just that if there's to be a variation of the directions, it's a matter for the first defendant to seek a variation from the court based on the evidence. At the moment, there is no evidence.
Yes, I appreciate that, Mr.
those-
Jackson, but you probably also appreciate that the court's attitude to it might be influenced by what the claimants have done and not done. For example, if there is a travel ban, if there is an arrest warrant, and if they have come about as a result of actions by the claimants, that might influence the attitude the court takes to whether the matter should be in person or remotely.
Yes, I accept that, Your Honour. But the critical question is whether an arrest warrant or a travel ban has been issued.
Yes.
That is not something that my clients are aware of. That will be a matter for the Dubai police. And my learned friend made the suggestion to you that, well, if there have been criminal complaints made, then they could be withdrawn. But in my submission, that is speculation, that would have any effect upon what the Dubai police might do. We don't have any evidence of how, if such complaints have been made,
All right,
how it would affect the Dubai police's thinking.
All right. I don't think we can take.
Sorry to cut across, Your Honour. I'm not
Doherty,
sure
yes.
I fully understand the nature of what's been said. I mean, it says in the claimant's witness evidence for trial that they've commenced criminal complaints in the UAE relating to misappropriation of funds from HI Dubai, forgery of documents, and so on. So, I mean, it must be within their knowledge. They've said in their witness evidence, so paragraph 34, I think, of the second claimant's evidence. It's not in the bundle, but it's clearly within their knowledge, and it's clearly within their understanding what these complaints are.
Sorry,
there are two issues, Mr. Jackson. Just wait a minute. But Mr. Doherty, Mr. Jackson is drawing a distinction between, on the one hand, the making of complaints, which plainly is within the knowledge of the claimants, whether they have or haven't made complaints, and if so, what complaints they've made. Mr. Jackson has made a distinction between the making of complaints and the issue of travel bans and arrest warrants. So I understand what he's saying is that, in effect, his clients know about the complaints but don't know about travel bans or arrest warrants. Now, I don't know whether, of course, they should know or what the processes are and so on, but that seems to be what Mr. Jackson's clients say. Now, I don't think we can take this any further today, other than arguing backwards and forwards about who should and shouldn't know and do and not do things. But I would ask you to do these things. You, meaning your instructors, should confer about this and do it quickly, not by leisurely exchange of correspondence, but by something which is going to get this to a head within days, not weeks. And if it is the case that Mr. Shehata is subject to any bans or warrants which practically impede him from attending Dubai, then that is a matter which I will give serious consideration to in determining whether the trial should remain in person or should be conducted remotely. And I will give, if that be the case, I will give serious consideration to the putting the parties on equal footing and so far as can be determined how the situation has come about and whether it's within the parties' ability to do something about it. Now, I can't say anything more than that, except to urge the parties to sort this out and not stand on technicalities, but to look at the practicalities of the matter and sort it out. And particularly, Mr. Jackson, whilst your clients may take the position that it's not us that have issued the warrants or the travel bans, they might want to address the practicalities of what if there are such bans or warrants, what effect that might have on Mr. Shehata, what effect that might have on whether the trial proceeds in person or remotely, and give consideration to whether they are able to assist in resolving the matter. So I urge you to sort that out quickly, and if it can't be sorted out, then probably it lies at you, Mr. Doherty, to make some application to, as you see fit, either for Mr. Shehata's evidence to be taken remotely or for a remote trial, and bearing in mind what I've said to you about my own convenience, the sooner that's done, the better.
Yes, understood, Your Honour. Thank you.
Thank you, Your Honour.
All right, what's next?
There's another issue in relation to the arrangements for giving evidence, which hopefully is a short issue. It relates to interpreters for the claimants. The claimants' witnesses have all filed witness statements in English,
Yes.
and they tend to give evidence in English. However, English is not their first language, and based on interactions between my instructing solicitors and the witnesses, from time to time, they may have difficulties in understanding particular questions put to them. For that reason, we seek permission from Your Honour that interpreters for the claimants' witnesses be permitted to attend trial to assist with interpretation if need be, in the event that any issues do arise with our witnesses giving evidence in English. It's merely a precaution to make sure that the process of giving evidence isn't interrupted.
Have you any difficulty with that, Mr. Doherty?
I don't think so, no. I suppose the fact that we've got a bit of flex in the trial timetable, I mean, it will depend on how things pan out at trial. Obviously, if you have evidence given fully through an interpreter, it can have time consequences and so on. But I think that there's the ability to deal with that within the timetable, and it sounds as though they're there as a backstop rather than as a translate every question and translate every answer.
Yes, I understood Mr. Jackson's application is simply that, his application is that the court should permit interpreters to attend. He's not yet sought an order that they should give their evidence through an interpreter. He would seek that order if and when the occasion arose. On that front then, Mr. Jackson, two things. You should, prior to the hearing, identify the interpreter or interpreters that you propose to be present, their qualifications, experience, and assurance of independence and impartiality, and inform Mr. Doherty's instructors of those identities, qualifications, and characteristics.
Yes, Your Honour, we'll certainly do that.
Well, I don't think it's necessary for me to make any order then at this stage, because you're not seeking, and I'm not giving an order at this time, that a witness give their evidence through an interpreter. They may be present in court, but as I say, you should ensure that Mr. Doherty's instructors are informed of their identity, qualifications, and characteristics, so that if and when you make the application, we're not going to hit a hurdle about objections on those fronts.
Yes, quite, Your Honour.
And the other thing you might, going back to what we were talking about before, it might be another spur for your clients to do what they can to assist to see that the matter is able to be dealt with in person, not remotely, Mr. Jackson.
Yeah.
All right, what's next?
The final issue, Your Honour, for the PTR is the trial timetable. As Your Honour knows, the trial is currently listed for 7 days, but the parties have put forward competing trial timetables.
I've only got one.
Well, the other one was annexed to my skeleton argument, Your Honour.
Well, tell me about it. The one I've got, and I'm not sure whose it was now, I thought it was an agreed one. That's why I only printed out the one. But that one provides day one, morning, oral opening submissions, afternoon, complainant's factual witnesses. Does yours differ from that, Mr. Jackson?
It does in two respects. I should say the overall time estimate the parties are agreed on. So both parties are envisaging that the time estimate should be reduced to 6 days in light of the fact that we're not going to be having expert evidence anymore. There are two differences between the parties relating to the running order for those 6 days.
Can I add one qualification to that, Mr. Jackson? That's a timetable done on the basis of an in-person hearing. Whilst one tries to do it as efficiently in a remote hearing, experience sometimes shows that things take a little longer when done remotely because of, amongst other things, more difficulty in dealing documents and showing documents to witnesses, additional problems if interpreters were to be involved. So whilst I'm satisfied with that timetable as things are presently scheduled for an in-person hearing, if because of the matters Mr. Doherty has raised, it becomes necessary or desirable to hold the hearing remotely, that might need to be revisited.
Yes, Your Honour, and for our part, we weren't envisaging that Your Honour would necessarily fix the precise timetable at this time. There are two differences of principle between the parties. The first is that we say day one should be allocated to pre-reading in our timetable. Whereas
Can you explain? It's not something that I'm not only not familiar with, it's something I've never done. Explain to me what it's about. Do you envisage that we should all sit in our separate rooms and read things?
Well, for our part, Your Honour, we hope the reading certainly will be done by then. It's something I have seen done in previous instances in the court. But of course, if the court has already allocated a pre-reading day prior to those days, then it's not needed, is the short point. If it's not needed, then we can take that out. The other difference in principle is the time for factual witnesses. The defendant suggests slightly longer, we suggest slightly shorter.
Well, let's deal with them a bit at a time. The plan I have in front of me, which from what you tell me is the defendant's plan, that allows 2 days for the cross-examination of the complainant's factual witnesses. Now that, I assume, Mr. Doherty, is your estimate of how long you will take to cross-examine. Is that right?
So I think the difference effectively, I think, between us is one additional session each for factual witnesses on my timetable. So I think Mr. Jackson's timetable had 3, so an afternoon and then a day for claimant's witnesses, and then
sorry, you're getting ahead of me. What does Ms. Jackson say? What time for the complainants, the claimant's witnesses?
If I can, when I say session, what I mean is either a morning or an afternoon.
Yes.
So Mr. Jackson provides 3 sessions, whereas I provide 4.
And well, you're the one going to be doing the cross-examining, Mr. Doherty. Your estimate is better.
Well, yes, quite. And also, it depends, obviously, what the court allows. But for 3 witnesses, I felt that was realistic. And then the difference in the defendant's witnesses, I think in my timetable, have allowed 3 sessions. And Mr. Jackson is 1 for Mr. Shehata. And again, his estimate might be better for that, but
sorry, Mr. Jackson, what's your estimate?
So our estimate for the defendant's factual witness is 1 day in total, so 2 sessions. For the claimant's factual witnesses, it's a day and a half, so 3 sessions.
Yeah, the difference, I must say, I always find counsel with the best of intentions. Their estimates are usually on the low side rather than the high side. Everybody probably goes in optimistically thinking, yes, I'll do it in a day, but I have no confidence that you'll be able to cross-examine Mr. Shehata about all of the matters in issue in 1 day. I don't know Whose estimate is the day? Is that yours or Mr. Montague Smith's, or who's estimated that?
It's a joint estimate between us, Your Honour. So we've discussed it.
Right.
I think the short point is that the timetable does have a lot of flex in it.
Yeah.
If you're minded to allow more time, particularly in the event that we did have a remote element to the trial, or the trial was remote in its entirety, then we can cater for that. Obviously, if matters change later on, then the timetable can be changed.
Well, I'm at the moment wish to leave it at 7 days. When you resolve the question of how the trial is to be conducted, then I might be persuaded to reduce it to 6 days. And your plan, as you say to me, is simply a plan. And what I propose to do with it is to follow it during the trial. That is, see how you're going. If you seem to be taking longer than the plan takes, then I'll be trying to hurry you up. And of course, we'll be going into the extra day.
Your Honour, just to flag, the only thing that we probably do need to be clear on, and I think I am, is that the first day will be kicking straight off with opening rather than it being a reading day, because it sounds as though pre-reading will be done before.
Yes. Day 1 or morning 1, housekeeping and opening submissions. Now on that, you've allowed only 1 session for oral opening submissions. It would be unusual if there were no housekeeping matters dealt with before we actually start the submissions. And secondly, then, even without them, it's not allowing much more than about an hour for each side. Is that going to be sufficient?
Well, for our part, Your Honour, we considered that given the trial is overall not a particularly long one, then oral openings could be kept quite short and leave the bulk of the submissions for oral closings. Of course, if Your Honour has a different preference and would like a more detailed opening, would benefit.
Well, no, just
the
caveat that I will be, if matters are raised in closing which have not been raised in either the written opening submissions or the oral opening submissions, then that will have consequences for the party who seeks to raise matters for the first time in closing submissions. So I don't encourage anybody to be prolix in their opening submissions, but I do, as say, give the caveat that if there's any matters you're going to raise in closing, they better have been raised in the opening, either written or oral submissions.
Yes, understood, Your Honour.
Okay.
If I could flag 1 point just on closings as well, Your Honour. And again, I don't think this is necessarily something you would need to be decided upon at this point in time. But if, for example, at some stage you formed the view that you were likely to be assisted by, say, written closings, and that you were looking to have those by the end of trial, in this instance, I'll obviously be doing the trial. Ms. Montague Smith will have the benefit of his junior, but as much prior notice as possible that you would be assisted by written closings would be much appreciated from my perspective.
Well, Mr. Doherty, you and I had a rather unfortunate turn of events in relation to that not so long ago.
And that's why I'm flagging it now, because if you think that there's a reasonable chance that you would be assisted by written closings and that you would like those on the last day of trial, that's obviously not necessarily an issue. It's just it would be helpful, as I say, not necessarily now, but at some point in advance of trial to know, so that provision and time can be allotted to produce those.
I most certainly will be assisted by written closing submissions. That raises the question of the timing of those, and that does raise these issues. They assist me, that is, the written closing submissions are of more assistance to me when they are able to condescend to the evidence that has been given. Now, perhaps I might just deviate at this point to ask, has either party made arrangements to have a transcript available or not? Mr. Jackson?
I understand we are making arrangements for that, Your Honour.
Right. I don't know, how does that work for you, Mr. Doherty? Does that, I suppose you've still got to pay separately for it, do you?
It might well be that that's something the parties can pick up and deal with.
The reason I raise it is because
if there's going to be live transcription, for example, would be one consideration.
Yeah. Well, I'm assisted, of course, by pinpoint references to evidence, and most by references to the transcript and the particular documents. Now, that does create issues, and one of which you flagged, Mr. Doherty. Mr. Jackson, you have the advantage of yourself and Mr. Montague Smith running things, as well as no doubt your instructor or instructors. Mr. Doherty, you have slightly less resources. Now, I don't wish to, as it were, put one party on an unequal footing by requiring written submissions with pinpoint references by the close of the evidence or the close of trial. I will be assisted by written submissions with pinpoint references. I invite you to discuss it between you to see what you can most conveniently do to assist me with that. And that is, the possibilities seem to me to be either that you deliver the written submissions before the end of the trial, or you do so at some short time after the trial. But I do wish to avoid the situation, Mr. Doherty, we had in that other case, where, in a sense, it was a bit of a moving feast and people felt disadvantaged by the changes. So perhaps if you could talk to Mr. Jackson and Mr. Montague Smith about that and see if you can reach an arrangement.
Certainly.
Yes, Your Honour, we'll certainly discuss that.
All right, good. Now, the other issue that you haven't raised but is put, I think, in your submissions or review somewhere, there are still pleading amendments and disclosure issues afoot. Is that right?
Yes, Your Honour. For our part, there are some limited amendments that we've proposed. Those haven't been consented to as at the current date, and the parties are still corresponding about that. I don't seek an order from Your Honour today. We, of course, recognise that if those amendments are to be advanced, that needs to be done in short order. So, in short, if it can't be agreed, it's likely an application will be made in short order. As to the disclosure complaints, there are a number of complaints that have been made by the first and third defendants. Again, the parties are corresponding on that. For our part, we are preparing a response to those complaints. We don't accept the criticisms, but we will aim to work constructively with the defendants to see if it can be agreed.
Okay. Yes.
I don't know if there's anything I particularly need to add. You've obviously seen my note, Your Honour, really to flag that one of the central issues when it comes to disclosure. Your Honour might recall the hearing that we had in relation to the first defendant's document production requests. One of the issues that had previously been taken and then dropped was this objection to disclosure based on possession, custody, and control. What appears to have happened in relation to the Al-Khalish documents in particular is that the same point that had been taken and then dropped by the claimants has found itself reinstated in the document production statement as a reason for refusing disclosure. If it's a point that should have been taken, it should have been taken at the hearing. And really that is there are other issues with the disclosure which have been identified I won't get into. That is one of the central ones, and if that isn't satisfactorily resolved, it's really to put down a marker that that's likely to come before Your Honour as an issue as well.
All right. Well, thank you. Well, to both of you, you'd probably gather the later and the closer to trial this is brought up, the grumpier I'm going to be. So please do. So please do it quick. Please do it quickly.
Yes, Your Honour.
All
That's
right.
from our side, Your Honour.
Mr. Dougherty?
Yes, I believe that's it, Your Honour. I think that the takeaway bits of work for myself and Mr. Jackson to discuss written closings and for our solicitors to discuss the criminal complaints and interpreters.
Yep. All right. Well, thank you both for your assistance today. And again, I ask you please to, in the spirit of cooperation, try and sort these things out. And if you can't, then let's bring it before me sooner rather than later.
Yes, thank you, Your Honour.
Well, thank you. And that concludes today's hearing.
Your Honour.